Okay, so welcome. It is Wednesday, February 26th, 2025, and we are in the Senate Committee on IT and Institutions. And today we are likely wrapping up our testimony on S69, which is an act relating to an age-appropriate design code. And we will likely be taking a vote on that bill. So the first witness we have is Damon Stewart, who's an attorney with Dish Network and DirecTV. So Damon,
Hello.
if you introduce, well, we don't know you, or you don't know us. So I'm Wendy Harrison, chair of the committee and Windham District. We can go around.
Senator Russ Ingalls, Senator from Essex District.
Senator Joe Major from Windsor.
And Rob Plunkett, the Bennington District.
Vice chair.
Senator Sam Boas from Orleans County District.
Great, thank you. Okay, so Damon, you have the floor.
Yes, thank you. My name is Damon Stewart. I'm here on behalf of DirecTV and Dish Network and their thousands of subscribers in Vermont. Just to be clear, I'm sure you're familiar with the fact that they both offer satellite video, but they also offer streaming services. Dish Network brands their streaming service as Sling. DirecTV, it's just DirecTV streaming. Overall, there are approximately 160,000 streaming customers in the state, and that includes DirecTV and Dish customers. I appreciate the time you're giving me. I know there's a lot going on. We'd like to express our respectful opposition to including Dish and DirecTV streaming services in Senate Bill 69, and we would urge the committee to narrow the bill's scope to address the public policy, the issue for which it's intended. We understand and support the goals of the bill to protect minors from unfettered access to inappropriate or harmful content that's widely available on social media. But the expansive scope of the bill as currently written vastly exceeds the source of the concern, social media, and instead it encompasses a much broader range of entities with no associated concerns such as streaming. That is, the burdens created to regulate the social media industry are imposed on an unrelated industry, namely DirecTV and Sling. Both companies require that anyone who purchases their streaming services to be at least 18 years of age. In addition, both companies have parental controls that allow a parent or a guardian to restrict viewing as they deem appropriate. So in other words, minors can't even get the service and parents can choose what the kids can see. Neither company, by the way, streams adult content. And upon signing up, and I think this is the key point I want to make, when you sign up for the service, both companies provide licensed media, which does not contain any user-generated, user-upload content. In other words, the issue at which the bill is directed does not exist with Sling or DirecTV. Unlike, say, Facebook or TikTok or Snapchat or all the other examples, there is no ability with the streaming services, Sling and DirecTV, to upload customer content. And to emphasize a phrase I use, licensed media, that is content that is licensed and regulated by the FCC. So really, in the context of this conversation, this bill, streaming services are the same as cable. By the way, if you just saw a TV set with the streaming service or cable service, they both have the same guide. You select your channel, you get the same pre-programmed programming available. You don't get to add your own, again, generate your own content. And it is worth noting, despite the almost exact position the two are in, cable is excluded from the bill. And I think for good reason. In fact, that concept of exempting distributors of others' media is explicitly recognized in the bill, implicitly by leaving out cable, explicitly because internet service providers, ISPs, are specifically exempted. ISPs don't, presumably because they don't create content, they just pass on what others create. Although it's an important difference that even with ISPs that are exempted, they can still pass on user-generated content. There is no means by which anyone can generate their own content and bump it up to DirecTV Stream or Sling. Yeah, the only difference is, again, between, say, ISPs and DirecTV and Sling is we offer licensed FCC-regulated content. So because we are in the same position as cable, because we're in the same position as an ISP, maybe even have some higher protections, frankly, we simply ask that we be treated the same as those two entities and excluded from the bill.
Okay, thank you for your testimony. Yeah.
Thank you once again for coming on. You said you had higher protections. What are the protections than cable?
But when I said, and compared to, say, ISPs, where if you just get an internet service, you can use that to upload whatever content you wish. Some of that I assume is the stuff, as the nature of which this bill is intended to prevent. But ISPs are nevertheless exempted. With DirecTV Stream and Sling, there's a higher protection in the sense that you just can't do that. There's no mechanism by which you can provide your own content to those platforms.
Okay, and I just want to let you know, this bill focuses on the algorithms, not the content. We're explicitly not focusing on the content. And the concern is the mechanisms and the way that the programs are designed, that design creates harm to children. So what you're explaining is likely not, but I can't say that for sure. We are going to look at the suggested modifications, amendments that were provided that may have been by you, but we are going to look at those later in this meeting. And also, this committee is just the first stop of this bill.
Sure.
But thank you very much.
Again, we do understand, but like I said, it's context. I mean, there's times when I've been in the Capitol explaining some differences in other areas, but in the context of this bill and the programming, we're the same as cable.
Right.
And we're probably both cable and us probably provide, as I just explained, a higher level of protection than just an ISP that's already exempted.
Yes.
So.
Yes. And I can see that. So thank you very much. And it's helpful that you were able to testify.
Do you have one question, Mr. You mentioned that the businesses you represent don't actually have minors as subscribers, so you wouldn't have any minors data, correct?
No, because if you sign up, you have to, again, we can only, if you're under 18, you can't get the service. We won't sign you up.
Okay, so almost nothing in this bill actually impacts you then, because there's no minimum duty of care, because it doesn't represent a covered minor. All of the different aspects of it you don't have to do. It's just maybe 2449E. Would that be the section that you're objecting to?
I think it's just the definition of covered entity. I mean, it's a little strange. The definition of covered entity includes us.
Oh, okay.
It doesn't
So
always fit
further to see whether
right.
Everything has to do with minors except for one brief part.
Right. We're defined.
You answered my question. Thanks.
Yeah.
Oh, okay, you're good. Okay, go ahead.
Hi, thank you, Mr. Stewart. So for DirecTV and Dish Network, what is the primary way that the companies represent generate revenue? Because under covered business, it talks about whose online products are reasonably accessed by minor, and you mentioned that those companies do have online products because you have like a streaming service and all that's online. But what percentage of the revenue generated by those businesses is online? Because if there is a possibility of adding another amendment, could say a company that has the primary amount of the revenue coming from online services, because then that would still hit the companies that the intent of the bill is trying to hit, while would exclude companies that do not have a primary amount of revenue.
Okay.
That's just a thought.
I actually appreciate that. I don't know is the quick answer. I suspect, and I want to be, this is me, not what I get from my clients. I suspect, and probably a goal would be to have a substantial amount of revenue from streaming as to that where the world seems to be going. So I'm not, I guess, let me find out if we can offer that, and that's something useful. But it just may not be given the nature of the company.
Thank you.
Okay.
I'm not saying no. I'm
Yeah.
a lawyer, right? I'm qualifying the answer. I'm sorry.
All right. Okay, any other questions? I think we're good. Thank you. Thank you very much. Appreciate your testimony. Okay. Our
Thank
next,
you for the time.
thanks. Our next witness is Mitali Jain. If I'm saying your last name right, hopefully. And founder Tech Justice Law Project. And she's going to focus on the legal side of this bill, which is obviously critical. And let us know what you think we need to know.
Well, thank you, Senator Harrison and committee members for the opportunity to testify today in support of Senate Bill 69, the Vermont Age Appropriate Design Code Act. The Justice Law Project, or TJLP, is a legal initiative that works with a collective of legal experts, academics, policy advocates, digital rights organizations, and technologists to ensure that legal and policy frameworks are constitutional and responsive to emergent technologies and their societal effects. We have advocated and continue to advocate for better, safer, and more accountable digital spaces. And we focus on platform design, the First Amendment, and data-based consumer harms. What I would say is I've been involved in this space, I guess, for the last several years. And the constitutionality and legality of different internet regulations is a very dynamic landscape right now in the US. Many courts, including the Supreme Court, have opined on one or more attempts to regulate the technology industry, and you're probably well aware of some of these efforts. We have been involved with supporting the Age-Appropriate Design Code since its early inception in California in early 2022. So we've seen a lot. We've since intervened as amicus curiae in a range of litigation supporting attorneys general offices around the country in support of kids' online privacy and safety regulation. What I can say confidently today in front of this committee is that the current bill text of Senate Bill 69 is very carefully worded so as to conform to this dynamic set of judicial precedents and where the law currently stands today. And I think that's something that upon first glance may not be apparent to those who have not been following these cases, but in fact, it is very carefully worded. Focusing on platform design, in other words, the conscious decisions made by technology companies about how to design their online services, products, and features, has increasingly been favored by lawmakers and regulators around the country. Also as a way to avoid the content trap of getting into protected expression rights. There's a growing number of strategies to leverage platform design, to advance platform accountability, and to reduce consumer harms. And this focus on design, I should say, is a preferred option on two levels. First, the constitutionality, which is what I'm primarily focusing on today. But as well, it's more effective as an approach to really combat the kinds of harms we see, because the intervention point is upstream. It's upstream from any specific content. When the intervention point is downstream on content, even assuming it were constitutional, you end up playing whack-a-mole, where you're responding to harms as they arise, and that's just not effective or sustainable. We see this kind of design approach reflected in a range of regulatory proposals requiring risk assessment, design standards, duties of care, transparency requirements, all of which are present in Senate Bill 69. These proposals incorporate a focus on a range of problematic usage, as well as unwanted or harmful features, privacy, and specific vulnerabilities of children. And that is the case with the AADC in Vermont. It has been carefully crafted, as I mentioned, as a design approach to regulation. Its primary objective is to prohibit unfair and deceptive acts to the youngest consumers in the state, and it has been explicitly tied to Vermont's consumer protection laws in its structure, its text, and its enforcement. It requires the highest levels of privacy and settings by design, carefully selected design prohibitions that do not infringe on content, transparency requirements that are seen as consumer-facing and therefore constitutional, and rulemaking authority for the Attorney General. Nearly all of these provisions have recently, in the last couple of years, been upheld by the Supreme Court, the Ninth Circuit, and several district and state courts around the country, many of those cases in which we have been involved indirectly. Industry has challenged nearly all internet regulation in the US, and should this bill pass, they too will likely challenge it here in Vermont. But I am confident that, having watched this landscape evolve over the last few years, that they will lose, and it will not be the first time that they have lost in the state of Vermont. In fact, just last year in the state of Vermont versus Meta Platforms, a Vermont court rejected Meta's First Amendment challenge of claims brought by the Vermont Attorney General against Meta for intentionally designing Instagram in a manner that is problematic for young people. The court found that Meta's argument failed to distinguish between its, quote, role as an editor of content and its alleged role as a manipulator of young users' ability to stop using the product. It also said that if the allegations in the Attorney General's complaint were proved through the case, it would be difficult for the court to see how these harms could not be considered a substantial injury. And so design as an approach has a legal analysis which really distinguishes it from content and therefore the First Amendment, and focuses on functional as opposed to expressive features and products of these platforms, and incentivizes these companies to design their products differently and towards safety as opposed to, towards harm. And so for those reasons, we support this iteration of the Vermont Age-Appropriate Design Code, and think that it is highly likely that it would be upheld as constitutional if and when challenged. And I'm happy to answer any questions.
Thank you very much. Do we have a question? I mean, she's addressing a lot of the concerns that have been raised the last few days.
I'm good.
Thank you for your confidence.
Yeah.
I guess.
Well, and for the Meta example too. So can you expand on that a little bit?
Sure. So as you may know, a number of attorneys general around the country have brought lawsuits against Meta in particular, and that follows a series of lawsuits that have been brought by families, by school districts, by municipalities. There's hundreds of lawsuits that are pending in the Northern District of California, in LA Superior Court, but then a number of AGs, filed together in the Northern District of California, but then a number of AGs, including Attorney General Clark, filed separately in state courts. And I think that was done with an eye towards really testing the sufficiency of state consumer protection laws. And so Vermont's case moved forward last year, and that's the basis of that decision, in which the Vermont State Court said that, in fact, Meta's attempt to throw out the lawsuit, suggesting that it was First Amendment violative, the regulation, was not convincing, because, if it were to take Attorney General Clark's allegations that she included in the complaint as true, that these were serious consumer harms that were not, that could not be conflated as being expressive activity that's protected under the First Amendment. And that's a pretty significant decision. So I think, you know, you have that precedent right there at home.
That's great. It's really good to hear. Yes.
What part of Meta's argument, or sorry, of the law, was Meta claiming was unconstitutional under the First Amendment? What part would they claim?
So I misspoke. The case that the attorneys general have brought, whether collectively in California or in the respective state courts, was not a case around regulation. It was a case around harms that the Meta products had caused to children in the state. And that was based on reams of documents that had been brought forward by the whistleblower from Meta, Frances Haugen, who you may recall came forward in the fall of 2021 and brought with her a number of documents that really exposed a lot of internal company knowledge about the ways in which the company was designing its products with conscious disregard for children. So it was on the basis of those documents that each of these state attorneys general have brought cases alleging affirmative harms, not on the basis of regulation. This Vermont Bill 69 would really be the first instance of regulating kids' online safety that I know of in the state of Vermont.
Does that answer your question?
No.
Do you want to ask it again? According to
Well, because you're mentioning that Meta was arguing around, or maybe you weren't referring to that case that the Attorney General brought. You mentioned Meta was arguing under the First Amendment. Was that a separate case you were referring to, or
no? So just to explain, the First Amendment would be applicable whether it's a regulation or whether it's an aggrieved party bringing a case against a company. In both cases, you have the First Amendment implicated. In both cases, what the technology companies say is that their expressive speech rights are implicated by these lawsuits. Because even if you know, I'm a harmed consumer and I say, you've harmed me because of the way you designed Instagram, what they will say is, well, these are our protected speech rights. We can design the platform as we wish, because as we know from Citizens United, corporations have speech rights in our country. And so what the court said there was that Meta could not hide behind the veil of the First Amendment, that these design features that were being alleged to be harmful were not, in fact, expressive. They were design features that really regulated functional characteristics of the platform and therefore did not deserve First Amendment protection.
that answers my question? Thank you.
that is a really, thank you. I'm glad we pursued that because that's helpful for me to understand also, probably other folks.
Actually, what court was that decision made?
Yes, let me tell you. I believe it was, let me see here. That was Vermont Superior Court in Burlington.
Okay,
Are they appealing that decision, Todd?
I'm sorry?
Or whomever,
Yeah.
it's any difference. Are they appealing that decision?
do
I'm
you
sorry?
know if they are appealing the decision?
I can check and get back to you. I don't, I'd
Well,
be surprised.
We do happen to have a representative from the Attorney General's office in the room that I can ask that question to later in the meeting. Thank you.
Sure, and I also want to say that that decision was a preliminary decision. It wasn't the kind of final decision in the case. It was responding to Meta's attempt to throw out the case on a motion to dismiss. So the motion to dismiss was denied, but the case continues.
Okay. Great. Thank you. Any other questions or comments or? Thank you very much for being here and for your testimony. It's very helpful. And if you could please send a written testimony, a written version, that would be great. Thank you.
Pleasure. Thank you.
Okay. So Todd Delos is our next witness. You're kind of a witness, you're.
When I sit here.
And you've been here before.
I haven't sat in the chair, so for the
Okay.
record, Todd Delos, Assistant Attorney General at Sherry Clark, with the Vermont Attorney General's office. And I will say, it sounds like Attorney Jane answered probably a lot of the questions that I anticipated you having for me, but I'm happy to respond to whatever questions and jump in wherever you'd like. I will say just at the outset that the Attorney General is a very strong advocate for data privacy, as you were just discussing. The Meta lawsuit is an element of that. I'm happy to provide a little more context if that's helpful. This bill is a key component of that work. We also anticipate testifying further on S71 or H208, which is a broader data privacy and protection act that we look forward to talking more about. But this is a really important component as well. And I think you've heard ample testimony, so I won't take up more of your time talking about the significant mental health issues. The Attorney General herself was here talking about those in the past. We certainly see that across the state and across the country as a result of this elements of this technology that this bill is really looking to provide additional transparency on and further control for protection of minors. So with that, I'm happy to talk about constitutionality. I'm happy to talk about litigation if those are elements that are helpful, or anything else that the committee would like.
Yeah, those would be helpful. We have some amendments coming up later. So I don't know if we would talk about those with you or wait for Attorney Sagel. But if you could speak to the constitutionality and if does anyone have any other specific questions?
Douglas, you were asking about cost.
Yeah,
Oh,
yeah, almost heard of
All right, it's on my-
Let's not.
Yeah, it's on your list.
So I'm happy to walk through a couple of them. I think Attorney Jane provided you a really good synopsis of the state of the law, and the phrase that she used that I would hold on to is, it is a dynamic landscape. And I don't want to sit in the chair and say there's zero risk of litigation. We fully anticipate there would be litigation around this, as there has been from industry on all of these bills. And I can't opine on, given that dynamic landscape, I'm not going to provide this is more likely than this. I will say that we believe this bill as drafted is very defensible. And to respond to a question I think you had yesterday, Senator Douglas, we defend the constitutionality of statutes almost across the board. There are very few examples where the Attorney General's office with existing staff doesn't take on that defense. The only one I could think of was probably a decade ago with the genetically engineered food bill. And that was because there was some additional funding that was allocated through a couple different mechanisms to provide for defense of that particular law. But otherwise, whether it is a challenge as an element of another piece of litigation, as was the case with the Meta lawsuit, where Meta was challenging the Consumer Protection Act, or existing consumer protection, which is what we brought suit against Meta for these harms under, and that's 9 VSA 2453. It's referenced in the age appropriate design bill, or a direct challenge to a statute related to another constitutional right that an individual or a corporation thinks has been violated. So as far as direct law, it's the attorneys we've got on staff who handle those cases, and our civil division, generally speaking, handles those, as does our appellate unit. That's not to say, in the interest of full disclosure for the committee, there is the possibility of attorney's fees upon losing a case, and that's an important consideration when we work on this kind of litigation. Beyond that, I know there were questions about rulemaking. We would defer to the committee in terms of who else is involved in any rulemaking authority that the Attorney General has here. Certainly consulting with other agencies can make good sense. Where does our expertise lie versus other agencies? I think that is an important consideration. And I would say, again, harkening back, I happen to do the rulemaking on the GE food bill, so that's why it was fresh in my mind. We definitely consulted with ag, we consulted with industry. When you put together rules, you want to make sure they are both true to legislative intent, first and foremost, but also applicable and functional for the regulated industry as well. And so we would anticipate a lot of engagement across the board if this bill passed into law. those were the top of mind questions, but I know, I'm happy to talk about the latest draft or there's
yeah,
nothing
we
specific.
don't have that,
Okay.
the amendment in front of us. Kayla, can you print out the amendment? Do you have the amendment?
Oh, I felt that I had. I guess, did I?
Oh, I'm sorry, there's a new amendment.
Oh, I didn't receive one.
I don't know.
In brief, Chair, I can
Okay.
say, I understand
Sure.
that council's gonna come, he'll talk you through it. I defer to the expertise that he brings. Most of what I see in this are policy decisions, not particular legal decisions that the AG would have a strong opinion on.
Okay, so let me ask, I don't think you're gonna be here when he's here. I don't know if you guys are gonna be here at the same time.
No, but I can work with Kayla and see if I can move things around this afternoon if you want me to know that.
Okay,
I'll try and keep tabs on it.
well, the threshold, is an important.
Yeah,
And it
so-
would be helpful if you can speak to that.
Absolutely. I understand there was conversation about, should this be directed at a specific industry or specific type of conduct? What I would say is if I were to lay out sort of most challenging to least challenging in terms of what if a bill faced litigation, what it would look like. The language that is provided that you'll see later this afternoon that provides a number of records threshold and along the lines that Senator Douglas suggested, a kind of income or gross revenue threshold. Those are facially and factually neutral. They have nothing to do with the content provided, the nature of the company, the ownership of the company, none of those things. And so we see that as a very defensible position. Again, it's a dynamic area of the law.
Yes,
So, a lot of the discussion has been about, the definition of covered business and essentially which businesses would fall under this. I'll be talking more about this later, but there's covered business that's defined and then also covered minor, that's defined and, almost pretty much all of the bill only impacts a business doing anything about covered minor. And covered minor is defined as a customer who a covered business actually knows as a minor or labels as a minor pursuant to rules. So my question is going to be is twofold. One, in terms of the lawsuits that could come to businesses. Can you describe what, an actual knowledge, I'm gonna call it NDRAV, it's not NDRAV, Stanter. Can you describe what that is versus what's needed for the Consumer Protection Act versus what's needed for the product? And how that would impact businesses. What I'm getting at is, this is really limited to what businesses would be affected. And it's pretty protective of businesses. If you agree with me, but if you can explain those different levels of proof that are there.
I will attempt to, but I would welcome further question or comment on it. I think actual knowledge is the demonstration that someone actually knows something, as opposed to constructive knowledge where you can infer that knowledge is held because somebody has provided enough circumstantial evidence to demonstrate that you should have known or you probably knew. I'm trying to go to the next one. So that's one end of the spectrum is the defendant in the theoretical case would have actual knowledge of, in this instance, the age of the minor, or under rulemaking, some other construct. On the farther end, I believe it's the way that you've laid this out, Senator, is a kind of strict liability regime that exists in product liability. And that means, generally speaking, consumer law, if a product is faulty and you were injured, you don't have to prove that it was intentionally made faulty, that the manufacturer knew it was intentionally faulty, or the like. There's strict product liability, generally speaking. That is not what this bill does. Is on the other end of this.
Yeah, what this bill does is you have to intend to do it to a covered minor. The other question I had is in terms of the definition of covered minor, and you might not want to answer this. This might be a question for Attorney Stagel. the definition has actually knows or labels as a minor pursuant to rules. And so both of those are essentially choices by the business to know their customer is a minor or make the determination to label their customer as a minor according to rules that the Attorney General provides. Would that be your reading of that definition?
Yes, but to your earlier caveat, I would leave that to legislature has to walk you through that. That is something.
So I think that sort of covers it in terms of the questions I wanted you as a lawyer that isn't the drafter to answer.
Fair.
Anybody else? I have a kind of procedural question or an educational question. Last session, and I don't remember which of the data privacy laws it was or bills. We included a provision where I believe it was the Attorney General's office would educate or facilitate education for businesses about how, you know, to do things the right way. And I'm not suggesting now, obviously, that we do that, but further, other committees later on may want that. And I just think it's notable that the Attorney General was willing to do that last year.
Yeah, and I appreciate the opportunity to comment on it. I will say that in anticipation of S71 at some point passing through the body, there is language existing in S71 about public education.
Oh, great.
That is the data privacy bill, not this age appropriate design bill. And, you know, we continue to be interested to engage, I mean, across the board with any consumer protection matter, like public health. The sooner you inform people, the better educated people are, the better they're able to prevent harm.
Right. Okay, great. And you probably heard we have that, or you may have heard.
I have heard.
We have it.
Great. So it'll be
So, okay, all right. Yes,
Can you be more specific on the costs? You mentioned attorney's fees very briefly. Could you be more specific? And I understand obviously the numbers are favorable, but your best estimate for the cost.
I would have to go back and look at similar litigation on a similar set of issues. But I'm happy to provide that in writing after this, just to give you sort of past litigation. One thing I will say is if we are successful in the defense of the lawsuit, then it's zero. Effectively. I mean, it's the cost of our attorney's time, but that's part of our base budget.
that's your job, essentially.
I guess I should
See, because were you talking about their fees? Or if we lose, then we may have to pay.
Yeah, the attorney fees are the.
Okay, all right.
And I suppose, I guess, maybe I am talking about also your salaries too. But these could be doing other things than defending this.
Yeah, I mean, opportunity cost is.
Yeah, and it's hard to.
I will say, it is not as though we would not defend another constitutional challenge or frankly, any lawsuit against the state.
And then once again, the AG is wants to do this. Support. Okay. Okay. Well, this has been very helpful and we can tag team now. We always have an attorney in the room today.
You gotta go.
Well, you all.
Oh, yeah. that's
Always
right.
have
That's
it.
here.
You guys are almost kind of the.
Well, they each have their little.
It's
their
like a
area.
proof.
Two there,
Give it.
two there, one here, don't know.
Almost. I should have introduced the committee. This is Maggie Chifulis. She's our policy intern in a 3L at Vermont Law.
Hi.
A soon to be, we anticipate.
Nice.
Congratulations.
Let's-
Thank you. Happy to come back.
Thank you.
Appreciate it. Nice to see you.
Okay. You know what? Let's take a little break just to get our paperwork.